All right, welcome everyone. I just want to take a few minutes to let more people come in, and so you are in the right place today for the webinar before you file and who really controls in Maryland. So get comfortable. If you want to take notes, go ahead and do that. I know a lot of people are getting off work, so I thank you for taking the time out to listen to this very important webinar that I have planned for you tonight. Tonight's conversation is going to entail what a lot of people don't think about early enough. And that's actually who controls your divorce once you file that case in a Maryland court. I'm going to focus on Maryland. I'm also licensed in DC as well. So we're going to start and talk a little bit about me. So my name is Attorney Sharice Williams, and I'm the owner of the law office of Sharice L. Williams. I have an office in Rockville. I've been practicing and licensed for 22 years, and I do collaborative divorce, I do litigation divorce, I do prenuptials, postnuptials, child support, custody, all of the things that you would imagine under the family law umbrella. And so I definitely like helping people in this area because it is like a journey when you start the process of getting a divorce. So I want to go over a few housekeeping things before we get started, just so everyone understands. I am going to talk throughout for at least 20 minutes to start the presentation. And there is a chat. So if you do have a question, feel free to communicate through the chat. Towards the end, for about 10 minutes, we'll have like a question and answer period. And just so everyone is clear, this is a webinar, so it is being used for educational purposes only. It's not legal advice, and it doesn't create an attorney-client relationship. If you do want something that is more specific to your case, you can contact our office. Um, but I do encourage you to speak to a lawyer regardless of whether you choose to contact our law office or not. But if you want to learn more, feel free to do that after this webinar. So let's get started. I've spent years helping people navigate divorce, and what I've realized is that most people who do come into my office, they don't come in saying that they wanted a long, expensive fight. They generally come in wanting to know more about how are they going to protect themselves. That's very common. They want to have clarity and they want to know what is the path that they're going to have moving forward. And they don't generally want to destroy everything that they've already built. So those are just common emotions, sentiments, things that are on their mind when they come in seeking information. You may have those same thoughts if you're thinking about divorcing your spouse. And what people don't often realize is how you divorce and how you start that process of divorce often can determine how stressful it's going to be, how expensive it's going to be, and how public it could be, depending on the facts of your case. So, one of the common myths that people have and things that I hear is I just need to file so people will tell me that they want to file so they can move things forward. And I do understand that feeling. Feelings like that, they often want to be the one to take action, right? It feels like you're in control if you file first. And some lawyers may even tell you that. Obviously, litigation, that's often one of the strategies that lawyers employ to get the head start and get the words before the court. But there are other sides to the reality of filing first. And there are things that I've learned and picked up over the years. So, one thing, once you shift the control to the court, you trigger a chain of events. So, it can often take away control in a lot of ways. So, thinking about that, the clock starts immediately. So, once you hand that filing over to the court, there's a set of procedural rules, regulations, and scheduling that the court is going to implement. And so, that often, once your spouse is served with that complaint for divorce, you can imagine it can escalate conflict or set off. Some spouses will go the opposite direction where they don't want to speak at all. They turn inward and they won't speak to you anymore at all. So also you have the idea of how lawyers, when getting involved, um, they're going to have to communicate and advocate on behalf of the spouse. And so it may cause your spouse to harden on certain positions that otherwise they may not have because now they're getting advice from somebody else. So it can often cause things that were clear, so you thought, they now become more rigid because once you realize your rights and what you're trying to protect, the language sometimes will change very, very quickly in between the spouses. So when you're being driven by deadlines, finances, attorney advice, they're not always client driven solutions. So that is definitely a myth that because you file first, that you're in control. So that's just something to keep in mind. And it's not always the best strategy. It really is a fact basis because each case, your family, your situation is unique. So you just need to take a moment and understand that there are options. Okay, when it comes to how the process that you use when you're going to get a divorce. And, if you don't want your spouse to necessarily be on the defensive, sometimes that's not the best course of action. So let's talk about what filing activates in Maryland once you file in the courts. So once you decide to file a complaint for absolute divorce, and we're going to talk about a case that's contested because that's generally, if you don't have a marriage separation agreement in Maryland, your case is considered contested. So when you file for divorce and marriage, the control and authority over that marriage is now within the jurisdiction of the court. They become the central decision maker. So you're now required to turn over mandatory financial disclosures. There's different forms depending on if you have child support, alimony within your case. I'm not going to get into all those details here, but those are forms that are required. Then you have the deadlines because there's certain hearings that have to occur within a certain timeline. So there's deadlines for that as well as deadlines for actual documents that you have to file. So these are forms and different things that are required in most cases, depending on what you're asking your spouse for. So all those things are triggered, and there's a schedule of events that have to take place. So the court controls what you're supposed to turn over, and obviously, there's a public case docket. So when you open a divorce, you're going to be assigned a case number. You're going to have this is generally open to the public. They don't display every single thing. So, but if someone wanted to request your record for news purposes and different things, yes, your case can become public. People can come to the courtroom and sit and listen to your hearing. Now, if there are allegations of child abuse and neglect or very specific things, there may be a reason to um, sh- close off and not make certain things public. But generally speaking, a family law divorce case is an open forum and hearing for the public. When you start a case in court, you have the option to file motions, to continue, motions for contempt, motions for all types of things. So if you don't agree on certain things, that's what ends up happening. So looking at all of that, um, then once you file a motion, there's a timeline for when responses are needing. You're going to have hearings set sometime. The court will continue a case or things aren't turned over timely. So as you can see, you're not in control of the timeline of things because things happen all the time during the course of a divorce. So your case begins to move at the speed of that system, not at the speed of your resolution. Sometimes you have lawyers that don't communicate very well, right? So you may have every intention to settle your case and be on that track, and the other lawyer just doesn't want to respond to your lawyer, right? These are things that you can't control. So the system and the process can get in the way. And this is where I find clients are very, very stressed out. And that increases, and the timeline increases, the cost increases. So once you're in that system, it's very hard to get control back. Now, if you settle your case within that process, then that gives you some control and authority as well. So now that we talked about kind of what is activated once you open a case, we're now going to discuss what judges decide and why it matters when thinking about filing in court. So you have a case that's going to be heard by, generally speaking, a magistrate. And once you have the magistrate involved, they're the ones that get to decide how marital property is divided. There's obviously law and things that they have to utilize to make their decisions, but you're going to present your evidence, and they're, based on equitable distribution, they'll look at the totality of marital assets and debt, and they have to make a decision on what, sometimes they have to decide what is marital property there if you don't even have it defined. So that's something the court gets to decide. They decide alimony decisions if that is something that is requested. They decided how it's awarded and for how long. You may have a case where you need relief right away. So there's something called pendente lite. So that's a hearing that maybe it's for temporary. So if you're divorcing now, you need alimony, temporary alimony, or temporary child support if kids are involved, or custody relief. Sometime you'll have a hearing before the final hearing, which is the actual divorce trial. So those things are decided by the judge. And so those are times when you put all of the decision making for stuff that, you may not even have all the evidence when you have a PL hearing. So again, judges often have to make decisions with limited information. So again, you're given the decision making and all of the control to the court. Um, Unless, like I said, you are able to settle things outside of court with your lawyers, but you'll still have to utilize the court, obviously, to get those orders signed off on. So, also, when we're looking at decisions that are made, we're talking about the enforcement of some of those orders. So, if there's something called discovery within a divorce case where you're entitled to information from the other side about what they're going to show in court, their evidence. So we have different forms of discovery. One is called interrogatories, which is questions that you can ask of your spouse. And sometimes people just don't answer those questions. There's something called production of documents, which is something that you turn over documents that you may utilize as exhibits. Some may, some may not, but you may be entitled to the financial records, bank records, text messages, various things can be requested in production of documents. But sometimes people don't want to turn those things over. So now you're going to have to ask the court to make them turn it over. So these are all things that the court will have to get involved. Motions are filed, arguments are made. Sometimes it takes until the day of trial for these decisions to be made. And so it's a very like convoluted sometimes, unclear process, and rules are not always stuck to a T, even though it may say, oh, you're supposed to turn this over in 30 days. I've had cases where the court still didn't rule on it till trial. So my client was very upset. And I'm trying to explain that we give a lot of discretion to the court when we're in court. So looking at once your case is involved in the court, it has to fit into those legal frameworks. And sometimes it just doesn't align with you and your spouse. And sometimes it would have been better off had you guys done this privately. So doesn't always fit. It's not always your live reality what the court's decisions will be made. So looking at that as something to consider when you're thinking about what process. So let's move on to what the court cannot do. So in a divorce, what the court cannot do for you, and we're going to look at, plan for your long-term financial efficiency. So first and foremost, looking at this process, divorce cases can range, I mean, in costs, they can range. There's like that's just a large range. Some people, if they're very fast and efficient and they can settle their case, they may spend less. Others can go on a year, sometime more, and they can spend 50, 60, over 100, $200,000. And we're talking, each spouse has their own attorneys. They're paying, each paying fees that are taken away from your resources that you may have to distribute between the two of you. So looking at that, a lot of people spend a lot of the money that could have been distributed amongst the two of you on legal fees. So it's just something that you have to think about. So the court, when they're making decisions, they're looking at the financial picture, but it doesn't always think about in the future what that really looks like for you. There's other ways that you can work your divorce and your financial planning without going through a litigated trial to do. So when we can also talk about they don't evaluate tax consequences in a meaningful way. Now, you can have your own tax advisors and different people outside of court because the court is not going to be the one to do that for you. So you don't want to you want to think about that also in advance when you're thinking about what process you're going to use, because these are all things after the divorce you want to be able to understand and know where you are going to end up in the end. So now we're talking about preserve your business. Let's say you have business together or you have your own. Sometimes things have to be shifted around, changed, or you're gonna have to split money between your spouse. So there's certain things when you go to court, there's legally they have to do, and especially if you're fighting. So essentially that could make things worse for you if you're a business owner. So looking at that is also a consideration when you're trying to figure out what process you want to use for your divorce. And also your privacy, if that is something that you really want to have preserved, because again, your sometimes financial information does get out, and things that you about your family and tough things that happen between your relationship, that stuff comes out in testimony. Court is not designed for privacy. It's for designed to get information onto the record, evidence, and so people will testify to the worst things about you, and they'll have drag your friends in to do the same thing, people that you thought were your friends and family. And so now everyone is in a position where they have to choose who to help, and that can destroy relationships long term. So court is not set up to help people maintain their relationships, and oftentimes that's one of the biggest things about litigation and the pain and hurt that comes from it in the end when people have to testify against each other. So let's talk about communication after your divorce. If you have a spouse that holds grudges, or you may hold grudges, everyone is, different the way that they operate. Going to court is not going to help you overcome that. And if you have children, that matters more than anything because you do have to co-parent. So if they've gone on the stand and said every negative thing for the last 10 years about you, it's very difficult to overcome that and work with them when you have a child that's 10 years old, and now you guys have to co-parent until this child goes to college, or at least leaves the house, whatever your child ends up doing. So there's a huge cost that comes from going to court that's emotional, that's not just financial. So you have to think about how much that is worth to you. So people don't really talk about that as much, but the aftermath, I'm sure you may have friends or family, you know that this is true. So they talk about how terrible their divorce was and how long it took and how much it cost. This hasn't changed. That's one thing that has maintained the same over all these decades. There are efficiencies now that they've changed, like no fault divorce and things, so you don't have to necessarily go into every single detail, but it's still details that you have to go into if you use the litigation system. So let's talk about the option, another process option that you can choose or think about other than litigation. And this is something called collaborative divorce. And so this can be used as one of your thoughts about when pre-filing legal strategy. So with collaborative divorce, it is a process. You're still going to be divorced, but the goal of collaborative divorce is for you to have a mutual consent divorce. So this is a powerful option, especially that you can use because you're not going to file first. Everything you're going to use in collaborative is going to be done before the court. So in collaborative divorce, both spouses first hire a collaboratively trained lawyer. That's one of the key things. I'm trained in collaborative. There aren't a lot of lawyers that are trained in collaborative, but there are enough. So if this is something that you're interested in, I highly recommend contacting my office. The one big difference with collaborative is that we actually recommend the lawyers that your spouse can hire versus litigation. There's no conversation about, oh, I'm going to hire this lawyer, you hire this lawyer. But in collaborative, that's exactly how we operate because we work as a team versus individual. We're not working against each other, we're working together. And so, lawyers that have worked together, doing collaborative, that is good because we're used to working together. So, Clients are remain in control of the decisions in collaborative. So lawyers guide the legal process and protect interests. So there's, depending on the case, there's teams that are put in place based on the necessary parties that you will need based on the case. So if there's problems with communication, we have coaches that help both spouses process and discuss information and deal with each other. Financial, who will help you both with your financials. So instead of hiring two experts in a litigated trial, one arguing about the value of this business and the other arguing the other position, the value of this asset, in collaborative, we will have one person working for both of you, and we will put all of your assets together so you can see the full financial picture, and you guys make decisions about how you want to separate all of those assets. So you are in control. You can do things that are creative. You don't have to abide by every strict rule in litigation. So, and excuse me. So it is very beneficial to families who aren't cookie cutter and things sometimes need to stay in a position. I can give a good example. Sometime in litigation, generally speaking, if a house is fought over by spouses and you go to trial, the trial will, and there's no one that actually can keep the house on a legal basis. Let's say there's no young kids and there's not use in possession arguments that can be made. That house is going to have to be sold. Where in collaborative, people have been very creative. They can keep a house to, in the family, even if they're divorced for several years longer than how a court would have the authority to order. So there's just more creative things that you can do to structure your divorce and your marriage separation agreement. So when it comes to the financial disclosures I mentioned before, we do exchange financial information in collaborative. Matter of fact, you have to be transparent. There's no hiding anything. We don't file motions against each other, begging you to turn over documents. This is part of what you agree to do with collaborative. But by doing that, we're turning over less documents. Everyone's at ease. There's no secrets, and you can actually understand the financial picture better so that you're not feeling like you're missing financial information that you need to make an informed decision, because that's the basis for turning over the information. You want to make informed decisions. So you don't have to be defensive and secretive in collaborative because it's not allowed. So there are no discovery battles, no duplicate filings, no waiting months for a judge to decide on a motion, because we're doing meetings with you and we guide you. And if you need a break, if you want to do more meetings, that's how we will set up the collaborative process. And we do all these things to help you, to guide you, to give you skills that you can even use co-parenting. The results are just better for parents. I'll emphasize this more than anything for people with kids, because they generally are able to communicate after this and co-parent, even if they just didn't get along. So, um, but you'll end up with that settlement agreement, and that is what you will need, and that is when and you can file with the court for uncontested divorce. So everything you need and everything you will do will be done before the court filing. So once you go to court, it's really just a matter of an uncontested divorce hearing. So that's one of the benefits. So let's talk about now why this process choice matters. So when looking at this, clients are in control of the process and the outcome, as I said before. You save time and money in the long run. So it may feel like, oh man, I have to hire people up front. But now we're not doing delays. We're not doing a bunch of court attendance. We're not hiring two of every expert. We're not, um, paying for endless discovery. And so you don't have to deal with all of those extra procedural things, including delays and all those things that will rise up the cost. So you get to decide the pace and the priorities. And for many people, and especially professionals, people who value their family, privacy, this approach not just protects your finances, but protects your children's peace. Because if the parent is less stressed, I find the children have been less stressed. I've represented children for my pretty much my entire career as a best interest attorney, as a guardian ad litem, you name it. And just from representing adults who have children, I've seen a lot. I've seen it through the eyes of the kids, and I've seen also how the parents are worried about their children, and sometimes they unintentionally do harm, and we know that's not the parent's intent. So, using a process where you from the beginning are setting up less burden and stress on your child is something that is worth considering. So when we look at understanding your options early, because you can talk about keeping your finances again and family matters private. For most people, that's super important. They may not understand that because in litigation, you may think, oh, it's not going to get out, but things do get out in the court. So if that is something you just want to avoid in general. So with collaborative, everything we do, because it's outside of court, the court never gets to see your financial report, your financial documents. All they will see is the uncontested complaint for divorce, the answer, and your marriage separation agreement. So it'll allow you guys to keep all of those pay stubs, tax reports, and everything else in within the process. So that's what I mean by keeping that stuff private. So looking at all of that, it is a very wise process option, and so it is something to consider when you're trying to figure out at the beginning of the year what you want to do next if you're considering divorce. And so getting and looking up and seeing if there's a collaborative lawyer, even if you don't choose myself, someone that can talk to you about your specific situation or what other options besides collaborative. Let's say there are other options such as mediation. That's usually one that most people have heard of, but there are options besides just going to the court, filing first, and then starting the process. Now, I don't want anyone to misunderstand. You can settle during the litigation process. But again, because you've initiated that process, you're still going to have to go up until do all of the procedural things up until that actual settlement agreement is officially decided by the court or entered into the court. So it just still you're doing sometimes two things at the same time, litigation stuff along with trying to settle. So double work essentially instead of just focusing on settlement. So there is a big difference. So I think for purposes of this webinar, I don't know if anyone had any questions. I don't see any questions in the chat, but now we can move on to the question and answer period. So I just want to, like I said, I don't see any in the chat, but there were some pre-submitted questions that I will answer. So one question someone had submitted previously was, when should someone speak with a lawyer if they're unsure? Which is a very good question. You should speak to a lawyer when you're starting to think about if you really are in a place where you've tried marriage counseling, you've done everything that you feel like you can do to salvage a marriage, but now you just think like you're at the end of the rope. And some people will come even if they're in marriage counseling, just so you know what options, because there may be some things you need to do to prep before you actually make that decision to move forward with a process, period. There may be some preliminary things that need to be put in place. So the more information you have, the better off you are with empowering yourself, giving yourself clarity, and making sure that you're choosing the right option for you and your family. Because sometimes you'll listen to your neighbors, your brother, your sister, everyone thinks that they know best, but ultimately it's your family, your spouse. You got together with them somehow, some way. So now this is you taking another approach to um, separate and then have to live separate. So you want to make sure that you're looking at your interests in totality, and just know all of your options. So that I would say as soon as you start thinking about it, but before you file. So you still have leverage and options if you do it at that point in the process. Let's look at another question that was entered was about, does collaborative divorce still provide you those same legal protections? Absolutely, yes. I'd say in a lot of ways, collaborative, in my experience, because as a lawyer, we're trained in the legal process, but as a family law attorney, we are bombarded with so many other areas when it comes to financial, accounting matters, mental health stuff, because when someone's going through a divorce, they generally have a lot of emotions. And so as a lawyer doing litigation, we're bombarded with all of that. And so it's we're not trained technically to do every area that is always we're always presented with in a lot of divorces. So in collaborative, we are able to bring on the proper people who have those experiences with that those particular things. So financial is someone that has expertise in finances, and so they come in and deal with that. If you need to sell your house, we have people that do mortgages and real estate that are trained and specifically in collaborative. That's the key because they know about this process and they can help you deal with getting a refinancing or getting selling your home. Or and when we're talking about your kids, if your kids need a voice in this process, you have kids that are older, there's child specialists who can be brought in to talk to your kids and give us a recommendation based on what your kids are thinking and saying and observing. And obviously, the coach helps facilitate communication between the team and the parties because that can often be very difficult. It's not an easy process. Just because it's not litigation doesn't mean everyone gets along or we're kumbaya. This is still sometimes a very long, hard conflict resolution, but those tools are in place, those strategies are in place, and it's set up to help with that. And your motivation is that you're agreeing to settle. So you're financially motivated to settle because if you don't, then you would have to fire the entire team. And most people don't want to do that. They sat down and decided that they're going to use this process. They'll work as hard as they can to get to a marriage separation agreement. So there's very few cases that ever fall out. I'm not saying it never happens, but it's very, very few. So when you're thinking about it and if your spouse doesn't know about it, there's ways to get more information so that you both understand at least the idea of what it is. So that's something. So another question is it less expensive? I would say I've looked at overall when I'm looking at the bottom, the line of the cost of divorces, litigation versus collaborative, and I'll say yes. It's usually like half or just at least less than half. So sometimes it can be a quarter of the cost of what a litigation can be for some cases. So yes, you may spend more on each professional up front, but the long-term cost is much less. So definitely going to save money in the long run if this is a process that you're both willing to hire lawyers because that's the key. Some people there's only one lawyer on one side, but with collaborative, that's not you're not able to do that. So that's very important. So I think those. Oh, one more question. I didn't even. Who benefits the most from collaborative? And I'd say people who are in a place where they do value having like a co-parenting relationship with their spouse, people that value privacy, they want efficiency, they like structure and control. And honestly, you have to be open-minded because there is a lot of talking with collaborative and there's meetings. So we do have to sit down and talk through issues. And so this is not just your lawyer talking on your behalf in court and then you show up at the trial and testify against your spouse. In this process, you are involved, you are talking, you are going to work. There's homework even in the process. And I'm not saying any of this to discourage you. It actually is very helpful. It keeps you actively engaged, both you and your spouse, but you're supported completely along the way. So it is a good process. So people that are open to all of those things, yes, this is something that is good and beneficial for those people. So thank you again, and we will be doing different monthly webinars, so you can come back again next month and stay tuned. But thank you for joining us, and have a wonderful rest of your day, night, wherever you are.